a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is your talkback lawyer and he's standing by for you. 1300 222 774 if you have a legal issue you need some assistance with. Hi, David.
Hi, Virginia.
Did you miss me?
Absolutely. But I was planning to chat with Ali today, but because you shifted your days off.
No.
Yes, you did, because you wanted to talk to Premier Dan.
Oh, that's right. Ali, yes, Ali needed a day, so it's absolutely delighted to be back earlier than expected. Any homework?
A simple question. Maria rang from, he says, because he writes these down, Chadstone. Maria and her husband's partner relationship has broken down. They want to shuffle properties. Mm-hmm. And I think of things.
What does shuffle mean?
Well, they just clearly, as a result of the breakdown, I get this stuff, you get that stuff.
Yep.
And was interested to know what the stamp duty bill would be. And the answer would be, if the transfer occurs as a result of the breakdown of a relationship, there is no stamp duty.
Oh, wow. That's a good fact to know.
Well, let's not encourage behaviour we might otherwise consider inappropriate.
That's not what I meant by that.
Yes.
And nor am I encouraging marriage breakdown either.
No, and also there are also capital gains tax advantages if the property transfer happens as a result of a breakdown in a relationship. But if there are just property transfers between partners because they want to rearrange their property arrangements, there might well be capital gains tax consequences. It's think carefully.
Think carefully, do the right thing. Let's start with John in Lara. Good morning to you.
Good morning. I have 3 adult children who are the only and equal beneficiaries to my estate. One was divorced last year but has not gone through financial settlement. Another has had a financial settlement but is not yet divorced.
Yes.
And the third separated about 4 years ago but has not done either, not divorced or financially settled. My question is, if their situations don't change before I die, would any of their former spouses have a claim on their share of my estate?
Let's take them. If the property settlement or the financial settlement has been achieved, absolute guarantee, no claim.
Okay.
All right.
Great.
Although I'm assuming you're not leaving $20 or $30 million, because every now and then you'll get someone who's gone through a property settlement and then there's a lottery win, and there's a sort readjustment on the basis of the new financial circumstances. The person who so there was one who's done a property settlement. There was another one who has long separated but neither divorced nor done a property settlement.
That's right.
It's very unlikely in those circumstances that the former partner would have any claim at all. Right. Normally what you're trying to do is what was the property pool at the time the relationship came to an end, and that's clearly some time ago.
Yep.
And you try and deduct from that the property that was brought into the relationship, and you're then dividing the balance. Okay. So if we were now talking about a significant windfall gain quite some time after the relationship came to an end.
Okay, great. Great, thank you very much.
Ensuring excellent. Good on you, John. Paul in Baldwin North, what's going on? Hello, Paul.
Hello, how are you?
Go ahead, you're on the air.
Okay. See, David, I have changed my name in 2018, and after that I applied for a university course and asked them whether I can go by my old name on my record, because I already have all the degrees and diplomas in old name.
Yes.
Hello?
Yeah.
And after completing maybe around, say, 90% of my my course, now they came up with the excuse that I have to provide some sort of evidence that I am Paul there actually.
You need to prove that you are who you were. Is that right?
Yes. And I actually, during that time, all my documents, new one, old one, wherever was the name issue, I supplied them with my name change certificate all the time.
Yes.
Now they say this is not the right thing to do. We got to go by old name on your documents, and you change the name. So they're putting me in some sort of trouble when they already agreed to it when I took the course.
Did they?
So
did they agree to it, or have?
Yeah, they agreed to verbally. and they accepted all the documents in my new name.
Sorry, so hang on. What you've got is this. You've got a course enrolment in your new name. You've got your
in old name.
So everything's in your old name.
Yep, yes.
Then I would be jumping up and down at the university and say, you accepted my enrolment in that name. I've done all my coursework in that name. I want you to award the degree in that name.
Yes, but now they're saying you have to prove that you was registered with that name, the new name. Then they can give me degree because I have completed 3 years of my Bachelor of Nursing degree.
Yes.
Yeah. And now they're saying, no, you wasn't registered at Paul with the new name, so it was not the right thing to do.
Is there no other documentation from when you went by that name, Paul? Your original birth certificate? You don't have any of that stuff?
I get that Virginia is the issue being slightly different. They're prepared to admit he's the same person, but what they want is to issue a certificate in the name that he now uses, as opposed to in the name that he once used.
Yes, that's the one.
Yep.
So what I should do now, because even maybe they can say, oh, you was registered as a wrong person. So
you'll still get credit for your coursework. But is this a qualification that you will need for employment?
Yes. It is Bachelor of Nursing. I will be registered nurse after that.
Yes, but do you want to be registered as a nurse in the name you no longer use, or do you want to be registered in the name that you do use?
No, I want that certificate in my old name, but I will register in the new name anyway.
Relying on a certificate in a name that you weren't using at the time you sought registration as a nurse.
Yes, but I supplied them with the name change and they agreed to it.
Okay, then I would just keep going back to the university. You accepted my enrolment, you've taken my money. And therefore, I want you to continue. And there will be an appeal process at the university.
That's after 4 years. And why the student have to go through when they don't keep the record of things?
Because there's a whole series of people who change their mind for different reasons at different times. There will be an appeal process at the university as to the identity issue.
So you'll have to find out how that appeal process works.
At the university.
At the university where you are. Paul, good luck with that. Another Paul, but this time from Flinders. Good morning.
Good morning. Good morning to you both. So I've got a situation, a very good friend of mine who is an NDIS participant.
Yes.
He, for a number of years, employed a NDIS worker through one of the platforms who subsequently went out on her own through her own business. He used to use her to take him surfing, used his surfing equipment. They've had a falling out. She's has retained a number of surfboards and wetsuits, and he can't get them back off her.
Yes.
We're just trying to find the best. We haven't gone to the police yet because he's worried that if he takes a heavy-handed approach, he'll just shut up shop and he doesn't even know where she lives. What's the best sort of approach to handle this?
What's the value of the items, Paul?
Oh, there'd be several $1,000s, I'd say.
Then my view would be, and do you have methods of contacting her?
Only through email. She's not answering the phone.
Then why would it not be something... You can't threaten to conceal a crime because that itself is a crime.
Yep.
But you could turn around and say there may be some misunderstanding between us as to the ownership of the surfboards and the wetsuits. They're mine. They're unequivocally mine. And the only assumption I can make if you do not return them within a week is that you never intend to return them, and that would be theft, and therefore I will go to the police station.
Yeah, okay.
Right. And clearly, if this person is charged, and particularly if this person is convicted of a dishonesty offence, they're never going to get any service provider to give them accreditation to deal with an NDIS patient.
Yeah, she was also employed originally to take photos of him as well. He was training for a particular job, and he has not received any photos from her.
Part of the confusion in this was this person employed directly or via a service provider?
Originally via a service provider.
Then I would be dealing with the service provider in relation to the photos, because that's the person who has the contract to provide the images.
Yeah, okay.
So, and that's the difficulty when you're dealing with someone under a particular employment arrangement, and then you try and change that. So deal with the photos with the first provider, and then deal with the wetsuits and the surfboards as I suggested.
Paul, good luck. Susan in Geelong, what's happening?
Oh, hello there. My partner has just died 2 weeks ago. And
Sorry, Susan.
thank you. We haven't got a recent will. He had a will from 2012 with his previous wife, who he divorced 15 years ago. And the children are saying, and she's the executor of that will because I wasn't on the scene at that time.
Yes.
And the children are saying that's the legal will. And I just wanted to check that with you.
Let's get these dates right. The divorce was 15 years ago.
Yes.
And the will was 9 years ago. 9 years ago.
Yeah.
All right. Had the will been before the divorce, the will would have been revoked by the divorce. Or not revoked, partially revoked. Anything that went to the wife would not have gone to the wife. Right?
Yes.
But because the will is 6 years after the divorce, the will is still the last will of your partner, but you have the right to make a claim against the estate for proper provision. So you have the ability to come along and say, I mean, how long were you together, Susan?
10 years, 9 years.
Okay. I'm a bit disappointed he made a will in someone else's favour shortly after he got together with you.
He couldn't help it because there was...
There were small children.
No, the property was not settled. He was divorced, but the property wasn't
Property
settled.
settlement hadn't happened. Susan, the will that you're talking about, the 2012, is a valid will. You have the right to make a claim for a provision, and on what my view would be, you will be very successful in that claim.
Yes, but does that mean his former wife is still the executor and I can't be the executor?
Well, you could never be the executor because you technically... Sorry, let's do this step at a time. Executor has to be someone appointed by the will. If you take on the role and you're not appointed by the will, you become what we call an administrator. Roles are the same, just a different title.
I see.
The second thing is that you could never be you could never be appointed the administrator because one of the requirements is that you promise to give effect to the terms of the will.
Yes.
And from what you're telling me, or from what I'm getting, is that the will is totally unsatisfactory.
Yeah, because I'm not even me and
no, I understand.
Children.
So, but it's very difficult to come along and say, yes, I promise to the court that I will give effect to the terms of my partner's will, but by the way, I don't want to because it doesn't provide for me. Your position is that you are a claimant against the estate. So you make a claim on the basis that your partner had a moral obligation to provide for you, that he did not because there were circumstances changes before he died and since the will.
Susan, is your partner's ex-wife, do you believe, going to be ill-disposed towards you?
Absolutely.
Right. So there's...
And my partner's ex-wife has a chronic medical condition, so her daughter will be actually taking over the executrix, and she is a lawyer and she hates me.
Then you need to lawyer up, as the as the music told you at the start of the program, Susan. So what you've got the advantage at the moment is that you have all the paperwork.
No, I had nothing because
you don't. You do not have the will, but you presumably lived with your partner when he died.
Yes, that's right. But since then, the children have come and removed everything that belonged to him.
Oh wow! Okay, lawyer,
including his vehicles, everything.
Yep, lawyer up, Susan.
Yeah, Susan, stop talking to us and go and talk to someone who has several names in the title of their organisation. Sue Grab It and Run, something like that. Susan, good luck.
Was it Dewey, Cheatham and Howe? Is that right?
Oh, wow. Will Susan be successful?
Oh, yeah, absolutely.
Yeah?
Yes. But we don't know how big the estate is. We don't know what the competing claims are.
But even if you're dealing with an executor as hostile towards you as that, the kids aren't in your corner either, they've cleared everything out, you've got no paperwork, she could still be successful?
I have every expectation that Susan would be successful. What if you think about it? Well, the rules in relation to costs in probate matters have changed, and it used to be that everybody got paid out of the fund and people divided what was left.
Yes.
If the ex-wife or the ex-wife's child is behaving inappropriately as an executor, then there can be costs orders made against them personally.
Was removing all the paperwork behaving inappropriately?
On one level, no. On one level, removing all the paperwork is making sure that you're in a position to do the job properly.
Sure.
I would point out to Susan that the car's an interesting question. When you buy a car and you register a car, they don't need to be in the same names. Registration relates to a person who accepts responsibility under the Road Safety Act, but it could be that my wife and I could buy a car, but it can only be registered in one name.
Danielle in Mill Park, how can we help?
Hello, good morning. In March, myself and my dogs were attacked by another dog.
Ooh.
I wasn't bitten, but I was injured, and I now have to have surgery later this month. I don't have private health, but I wanted to know, given that I wasn't bitten, the dog owner is still liable to pay damages or to pay for my surgery, essentially.
Why and how were you injured, Danielle?
Basically, the dog knocked me over and I got dragged from the footpath into the gutter.
By your dog?
No, by their dog.
How does the dog knock you over and drag you? Or drags your clothes?
So their dog ran out of its house down the street and started attacking my dogs. One of my dogs took off. The other dog I've got on a retractable lead. Their German Shepherd got caught up in the retractable lead and was thrashing around. And I got dragged or I kind of was a bit wiped out at that moment. So.
The short answer is yes, you do have a claim. And as the general proposition is that it's the responsibility of the person who had control of the dog. And when I say control, if you're in my property, the expectation is that I will be looking after the dog. So it's the person who occupies the house where the dog was.
Yeah, and even if this didn't happen at their house and it was just on the street, they still have the onus of responsibility?
Yes.
Yeah, all right, fantastic. Thank you so much. I appreciate that.
Thanks, Danielle.
Danielle, we hope that goes well. We're returning to will and probate issues. Tony in St Kilda, what's going on?
Hi, morning all. I've recently partnered and have lived with my de facto partner for in excess of 5 years. We've had assets before repartnering. We now own joint property. My partner doesn't have any children but has 4 siblings. We're going to redo our wills, and the notion is that we're going to leave our estates to one another when we pass.
Yes.
If my partner passes, can any of her siblings contest the will? Is the question.
Your siblings are not, your partner's siblings are not able to contest your sister's will for a larger share on the basis of the relationship. If they were part of the household in which you both lived when she dies, yes, right?
Right.
The only way they could challenge your will would be on the basis of lack of testamentary capacity at the time the will was made.
Oh, okay.
All right, so if that's not an issue, and I'm presuming it's not an issue, your partner's siblings will have no claim.
Okay. What about if my partner decides to leave some of the estate to 2 of the siblings? Can the other 2 then contest the will?
No.
Okay.
Each of them has this. Whatever rights are held individually and not collectively. So there is no obligation in the event that that your partner decided to leave money to one but not all siblings, then the other siblings have no claim.
Okay, that's it.
Good luck.
Thank you very much.
Hope that goes well. Kevin in Narrow Warren, good morning.
Good morning. I'm a self-funded retiree landlord, and the rent I get is part of my income, and I've got a tenant who is nearly $2,000 in arrears, and I'm going through all the process with VCAT, but there's an 8-week wait, in which case then she's 8 weeks behind again with her rent. I'm wondering if there's any other thing I can do through the courts to either get her out or get the rent money.
You are able to sue for rent, I think, You certainly are in a commercial premise. Is it commercial or residential?
No, residential.
I'm not sure what the residential answer is, but the general proposition is in a commercial tenancy, and the acts are similar, is that you can sue for rent, but you can't sue for outgoings and you can't get an order for possession.
No, I'm doing that through VCAT.
So
the problem is that there's an 8-week delay. So in 8 weeks, she owes me another $2,000.
Right, but I can also tell you that that you're not going to get a hearing in a magistrate's court inside 6 months. Right?
Yeah. So
VCAT, and when you get to VCAT, you will amend the application to bring the rent amount up to date.
So I plan to do that.
Yes. So
what VCAT is doing is, when I first put in the application, she was only 3 weeks behind. By the time I get to my hearing on the 30th of August, she will be
11 weeks behind.
12. Yeah.
And, I understand.
She owes me more money, it's creating a problem for her as well.
Kevin, I've had a couple of emails from various people about significant concerns of delay at VCAT. So I've gone to VCAT and said, could you give me an indication as to the amount of as to the delay in various lists at VCAT? And they're not able to do that. Or haven't yet responded, I think is the best way to say it, is that, so I would be coming along and saying, at the moment, your VCAT waiting list is shorter than it would be at any other court.
Yeah, which is 8 weeks at the moment.
Yes.
Yeah.
Yep.
Just got to file the paperwork and wait it out.
Yes.
Is that the only?
Yeah.
I think we can fit in one more time, one more call. Just 1 second. I think we're over to Wills as well. Michelle in Surrey Hills, hello.
Hi. I just wanted to ask, my mum has dementia, and we were there was a change to be made to her will, but because of COVID, we didn't get to do it, and her dementia decreased, and she now doesn't have capacity. So my sister and I are the two executors of her will and the two essential inheritors of her will, and we both know what her desires would have been, but unable to change anything. I'm just wondering, when Mum does pass away, can we just make the decisions ourselves to divide her estate in the way that she would have wanted but wasn't able to change?
Between you are the beneficiaries of the will. You can do what you like.
Right.
Now, get some advice at the time, because there may be some stamp duty issues or capital gains tax issues, but essentially, between you own whatever it is, or you will own whatever it is that your mum leaves, and you can deal with it as you see fit.
Okay, great.
The change that was going to be made, Michelle, that's not a material change to the division of the estate?
Yes and no. So there was a property purchase made in my sister's name, which didn't get added to the will. So the will would suggest that Mum's estate needs to be divided in half, but the house would have been taken into account, but we didn't get to make that change.
Well, I'm still at the same point. Where you get to is, what extra allowance do I give to Michelle from Mum's will on the basis of the benefit that my sister has already received?
Yeah.
That's a discussion. There's no point having that discussion now.
Yeah.
Well, you can have an in-principle discussion now, but you can't give effect to it while your mum's alive.
No, that's right, yeah. But once she's died and the will says we have to divide the remains in half, we know what she wanted.
You can have an argument then.
I don't think it'll be an argument.
No arguments.
Excellent.
No. Let's
Michelle.
have no falling out over wills. We don't need it. David, always good to see you. Thanks so much. David Whiting back with you next week to help you with any legal problems that you might have.